All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and forensics for immersion. The holding cell beneath the Granite County Courthouse smelled of decades-old disinfectant and something metallic that might have been fear or just old pipes. Rook sat on the concrete bench, hands folded in his lap, listening to the muffled cadence of voices filtering through the ceiling. 28 years had carved lines into his face that didn't belong to a man who'd entered prison at 23. The fluorescent light above him flickered in the same irregular pattern it had during his arraignment, during his sentencing, during every court appearance in between. His public defender, North, appeared at the cell door with a leather briefcase under one arm and eyes bright with something Rook had learned not to trust over nearly 3 decades. Hope was a currency that bought nothing in places like this. "Judge Keystone wants to see the supplemental report herself," North said, voice low and urgent. "The Arcadia lab retest results. She's reading them in chambers right now." Rook didn't move. For 28 years, the state of Granite County had said his DNA was on the victim's clothing. The jury had heard expert testimony about it. 3 levels of appellate courts had affirmed the conviction based on it. And now a forensic analyst named Juniper, who hadn't even been born when Rook was convicted, claimed the original analysis was fundamentally flawed, claimed the DNA profile didn't match him at all, claimed the sample had been compromised by improper storage protocols and cross-contamination with another case's biological evidence in the same freezer compartment. "What happens if she believes it?" Rook asked, his voice rusty from limited use. North crouched so they were eye level through the bars. "Then we get you out of here, today." But getting here, to this moment, this cell, this razor's edge between vindication and another denial, had taken everything Rook had left after the system had already taken everything else. The courtroom gallery was nearly empty when the bailiffs brought Rook upstairs 20 minutes later. His sister sat in the second row, grey-haired now where she'd been brunette with highlights at his trial. Across the aisle, the victim's brother watched with arms crossed over his chest, jaw set in the same rigid line of grief and rage Rook had seen at sentencing. Between them, the space where certainty used to live had become something else entirely. Something fragile and combustible. The crime had happened on a January night in the industrial district of Riverbend, in a narrow alley behind a shuttered textile warehouse that had once employed 300 workers. The victim, a woman in her early 30s, known in this account as Vale, had been found by a delivery driver making an early morning run. Blunt force trauma to the back of her head, defensive wounds on both forearms suggesting she'd tried to protect herself. Her winter coat torn at the shoulder seam. She'd been alive when the paramedics arrived, pulse thready but present, but she never regained consciousness. She died 4 days later in Riverbend General Hospital without speaking a single word about her attacker. The physical evidence was frustratingly scant for such a violent crime. No weapon was ever recovered from the scene or surrounding area, despite extensive searches. No witnesses came forward who'd seen the actual attack, though several businesses had security cameras that proved to be either non-functional or pointed in the wrong direction. But Vale's dark blue winter coat yielded a partial DNA profile from a bloodstain on the collar, approximately 2 centimeters in diameter, and her right hand showed traces of epithelial skin cells beneath 2 fingernails on her dominant hand. The medical examiner, a pathologist named Crane, noted bruising patterns consistent with a sustained physical struggle lasting several minutes. Detectives also recovered a cigarette butt near the body, later typed to an unknown male contributor who wasn't in any database. The lead investigator, a 20-year veteran sergeant named Harbour, made the strategic decision to focus investigative resources on the blood stain and the skin cells under the nails. Those became the entire case. Rook lived 6 blocks from the alley in a rent-controlled apartment he'd occupied for 4 years. He'd been questioned twice in the weeks immediately following Vale's death. Once, because a neighbor reported seeing him walk past the warehouse on the afternoon before the attack during his usual route home from the grocery store, and again because his work schedule as a delivery driver for a regional beverage distributor placed him off duty the night Vale was attacked. His route covered the industrial corridor where Vale's office was located. She worked as a payroll clerk for a manufacturing firm 2 streets over from where she died. Harbour noted the geographic overlap in his case file with 2 underlines in red ink. The DNA sample from Rook was voluntary, obtained during the second interview. Harbour asked in a conversational tone if Rook would be willing to provide a reference sample to eliminate himself as a person of interest. Rook, who'd never been arrested and had no experience with the criminal justice system, complied immediately. He had no attorney present and didn't ask for one. The buccal swab went to Arcadia Lab, a regional forensic facility that handled DNA analysis, toxicology, and trace evidence examination for Granite County and 3 neighboring jurisdictions under a cost-sharing agreement. 6 weeks later, the analyst assigned to the case, a technician named Drift, who'd been with Arcadia for 11 years, reported a match in a 3-page laboratory report. The DNA profile generated from the bloodstain on Vale's coat collar and the profile from Rook's reference swab shared 13 of 13 analyzed genetic loci, using the standard STR typing method employed at that time. Statistical weight, approximately 1 in 4 billion in the general population. The report concluded with Drift's signature and the lab certification stamp. Rook was arrested on a Thursday morning in his apartment while getting ready for work. His mother, who'd stopped by to drop off a casserole, watched from the doorway as 2 detectives cuffed him and read him his rights. He told her it was a mistake, that he'd never even met Vale, that he didn't understand what was happening. She believed him completely until 3 days later, when the county prosecutor, a veteran attorney named Slate, who was up for re-election that year, held a press conference on the courthouse steps and said the forensic science was irrefutable and conclusive. The trial began 11 months after the arrest, following standard pre-trial motion practice and discovery exchanges. Slate, methodical and confident in his presentation, built the prosecution's case on 3 interconnected pillars that he wove together in opening statements and reinforced throughout the evidence phase. First, and most critically, the DNA evidence. Drift took the witness stand on the 4th day of trial and testified for nearly 3 hours about the collection, analysis, and interpretation of the biological material from Vale's coat. The blood on the collar came from Rook with near absolute certainty, Drift explained, walking the jury through allele frequencies and probability calculations. The match was complete across all 13 tested markers, a level of concordance that left essentially no room for coincidence. Cross-contamination was impossible, Drift stated under direct examination, because samples were processed in separate analytical batches weeks apart, and the laboratory followed strict chain-of-custody protocols, including documentation at every transfer point, refrigerated storage in designated freezer units, and separate workstations for evidence and reference samples. Second, a jailhouse informant who became the prosecution's most damaging witness. A man named Kane, awaiting sentencing on an unrelated residential burglary charge in the same county jail where Rook was held pre-trial, claimed that Rook had confessed to him during late-night conversations in adjacent cells. According to Kane's testimony, Rook had described the alley in detail, the struggle with Vale, and one specific detail that the prosecution emphasized had never been released to the media or public. That Vale had been carrying a canvas tote bag with her employer's logo on it, which was missing from the scene and never recovered. Slate presented this piece of testimony as powerful independent corroboration of Kane's credibility. How could Kane know about the missing bag unless Rook had told him? And how could Rook know unless he'd been there? Third, the circumstantial web of proximity and opportunity. Rook's beverage delivery route put him in the industrial district 3 days a week. His personal vehicle, a 10-year-old sedan, had been spotted by a warehouse security guard near the area on the evening of the attack, though the guard couldn't specify the exact time and admitted on cross-examination that he hadn't paid close attention. Rook's alibi for the night in question was weak. He claimed he'd been home alone watching television with no one to verify his presence. Slate threaded these facts into a narrative of accessibility and intent during his closing argument. The jury heard that Rook had been near the warehouse before the attack, that he had the means and opportunity, that his own genetic material was found on a dying woman's coat, and that he'd confessed the details to another inmate. Rook's defense attorney, a court-appointed lawyer named Gable, who was handling 7 other felony cases simultaneously, challenged the informant's credibility with vigor, pointing out Kane's extensive criminal history and the obvious incentive he had to fabricate testimony in exchange for sentencing consideration. Gable also emphasized repeatedly that the cigarette butt DNA found near Vale's body didn't match Rook. It matched someone else entirely, someone who'd never been identified or investigated. But Gable had no financial resources to hire an independent forensic expert to counter Drift's testimony about the DNA match. The county's public defender office operated on a budget that didn't cover expert witnesses in most cases, and Rook's family couldn't afford to pay privately. Gable argued reasonable doubt based on the unidentified cigarette DNA and the weakness of the circumstantial evidence. But the DNA match on the coat was an evidentiary wall he simply couldn't breach without technical expertise. The jury deliberated for 9 hours over 2 days. When they returned to the courtroom, the forewoman, a retired teacher, read the verdict twice because Judge Keystone, a different Keystone, the predecessor to the current judge presiding over today's hearing, asked her to repeat it for absolute clarity. Guilty of second-degree murder. Rook's mother collapsed in the gallery. His sister held her upright while the bailiffs moved to clear the courtroom, and Slate shook hands with the lead detective Harbour. Sentencing came 3 weeks later after a perfunctory pre-sentence investigation. Judge Keystone imposed life imprisonment with the statutory possibility of parole after 25 years. "The evidence presented at trial leaves no room for doubt about your guilt," she said from the bench, looking directly at Rook. "You took a life with violence and deliberation. The jury heard overwhelming scientific proof of your involvement. This sentence reflects the severity of your crime and the community's need for protection." Rook appealed through the standard post-conviction process. His direct appeal, filed by an appellate public defender, argued ineffective assistance of counsel based on Gable's failure to obtain an expert witness and insufficient evidence to support the informant's testimony given Kane's obvious bias and lack of corroboration. The state appellate court affirmed the conviction in a published opinion, finding that Gable's performance met minimum constitutional standards and that the DNA evidence alone was sufficient to support the verdict even without the informant. The state Supreme Court declined discretionary review. Federal habeas corpus petitions were similarly unsuccessful. Rook's case joined the files of the conclusively adjudicated. Inside the state correctional facility at Coldbrook, a maximum security institution 4 hours north of Riverbend, Rook learned the rhythms and rituals that replace what used to be called a life. Morning count at 6 a.m. sharp, breakfast at 6:30 in a cafeteria that smelled like industrial cleaning solution and overcooked eggs. Work detail in the furniture assembly shop until 3 in the afternoon, building institutional desks and filing cabinets that would be sold to other government agencies. Dinner at 5, recreation yard time if the weather permitted, lockdown at 9. The routine was identical every day except weekends, when work was replaced by additional yard time and religious services for those who wanted them. He wrote letters obsessively during the first 5 years. To Gable, asking about post-conviction options and newly discovered evidence standards. To innocence advocacy groups whose addresses he found in the prison law library, pleading for case review and investigation. To journalists at newspapers in Riverbend and the state capital, hoping someone would examine the inconsistencies he'd identified in the trial record. Most letters went unanswered. A few generated form responses expressing sympathy but explaining limited resources. One response came from an innocence clinic at a law school 3 states away. But after reviewing the case file, they concluded they couldn't take it without some new evidence that wasn't available at trial. A legal standard for post-conviction relief they couldn't meet with the existing record. Years became decades, with a slow inevitability that felt like erosion. Rook's first parole hearing at the 25-year mark was a brief procedural affair that ended in denial. The 3-member parole board cited the violent nature of the offense, the lack of prior criminal history that might suggest the crime was an aberration, and most significantly, Rook's continued refusal to accept responsibility or express remorse for Vale's death. Acknowledgement of guilt and genuine acceptance of responsibility are prerequisites for release consideration in a case of this severity, the board chairwoman stated for the record. Rook, seated across the table in prison whites with his hands folded, told them quietly that he had nothing to accept responsibility for because he hadn't committed the crime. They scheduled his next hearing for 3 years out. In his cell, a single occupancy unit he'd earned through good behavior and seniority in the prison hierarchy, Rook kept a cardboard file box. Inside were copies of every pleading, motion, and brief filed in his case. Newspaper clippings from the trial that his sister had saved and mailed to him. The trial transcript, which he'd formally requested from the court clerk and received in installments over 2 years. He read and reread these documents until certain passages were committed to memory, underlined in pencil so many times the paper had worn thin. Drift's testimony about batch separation and contamination prevention protocols. Kane's detailed knowledge of the canvas tote bag. The cigarette butt DNA that Slate had argued during trial was irrelevant, probably left by a homeless person or passerby days before the attack, unconnected to the crime itself. The evidence log from Arcadia Lab listing item numbers and storage locations. Vale's coat sample was item C47, Rook's reference swab was item R12. Storage notation, freezer bay 3, shelf B, both items logged into the same location in the laboratory's evidence management system. That last detail, the storage notation, never made complete sense to Rook. If samples were processed in separate batches weeks apart as Drift had testified, why were they stored in the same freezer bay and shelf? But he wasn't a scientist. He didn't understand laboratory procedures, and every court that had reviewed his case had found the DNA evidence reliable and properly handled. In the 26th year of his sentence, a small news item appeared in the Riverbend Herald that Rook's sister clipped and mailed to him. Arcadia Lab was under investigation by the state's Forensic Science Oversight Board following an internal audit that had revealed systemic irregularities in evidence handling procedures. The article was brief and vague, mentioning quality control concerns and administrative review without providing details. Rook filed the clipping in his box and tried not to let hope take root. Hope was dangerous. Hope led to disappointment, and disappointment in prison could break what little remained intact. 6 months later, the Oversight Board released its findings in a public report. The audit had uncovered significant problems spanning a 15-year period at Arcadia Lab. Evidence samples from different cases were routinely stored together in the same freezer compartments without adequate separation or barrier protection. Contaminated pipettes and other laboratory instruments had been used across multiple analytical batches without proper sterilization between uses. Chain of custody documentation was inconsistent and sometimes incomplete. Quality control measures that should have caught these problems had not been implemented or had been ignored. The report identified hundreds of cases potentially affected by these lapses, though it didn't list them individually. North, the new public defender who'd been assigned to handle Rook's file after Gable had retired, read the Oversight Board report and immediately cross-referenced it with Arcadia Lab's internal case logs, which had been made available as part of the audit's public disclosure requirements. She discovered that items C47 and R12, Vale's coat sample and Rook's reference swab, had been stored in Freezer Bay 3, Shelf B, alongside 43 other biological samples from 19 different criminal cases, some involving violent crimes with significant blood evidence, some involving minor property offences, all processed and stored during the same 6-month window in which Rook's trial evidence had been analysed. The Freezer Bay's temperature logs showed multiple unexplained fluctuations. Several evidence tubes from that storage location had cracked seals, according to photographs taken during the audit. North filed an emergency motion for post-conviction DNA testing under the state's recently amended statute that allowed retesting when new scientific methods or newly discovered evidence cast substantial doubt on the reliability of original forensic results. The motion argued extensively that the Oversight Board's findings constituted newly discovered evidence of potential cross-contamination, that modern DNA analysis methods could determine whether the profile attributed to Rook was actually his or the result of sample mixture or transfer from adjacent evidence, and that such testing would likely produce results material to Rook's actual innocence. Slate, now a senior supervising prosecutor in the Granite County District Attorney's Office with responsibilities for post-conviction litigation, filed a vigorous opposition. The defendant seeks to exploit unrelated administrative concerns at Arcadia Lab to undermine a conviction supported by overwhelming evidence, Slate wrote in his brief. The original DNA analysis was conducted by a qualified forensic scientist using accepted methodology. The match between the defendant's reference sample and the evidence sample was absolute and conclusive. Storage proximity does not equal contamination. The defendant has failed to demonstrate any actual evidence of compromise specific to his case. This motion is a transparent attempt to obtain unwarranted post-conviction relief through speculation rather than proof. Judge Keystone, the current Keystone, who had inherited Rook's case 2 years earlier through the court's routine reassignment process when the previous judge retired, held oral argument on the motion. North appeared in person with Rook present in transport restraints. She argued passionately that the Oversight Board's findings were not speculative but documented fact, that the storage conditions created an unacceptable risk of cross-contamination that undermined confidence in the original results, and that modern probabilistic genotyping methods could definitively resolve the question of whether the DNA profile was truly Rook's or a laboratory artifact. Slate argued that post-conviction relief required new evidence that was material and likely to change the outcome, not merely create doubt. Every convicted defendant would like a do-over of their forensic evidence using newer technology, Slate told the court. That's not the legal standard. The defendant must show actual evidence of contamination specific to his samples, not just that contamination was theoretically possible. Judge Keystone took the matter under advisement. 3 weeks later, she issued a written order granting the motion. While the court is mindful of the high burden for post-conviction relief, the Oversight Board's findings regarding Arcadia Lab's evidence storage practices during the relevant time period, combined with the specific storage proximity of the defendant's samples, present sufficient grounds to warrant retesting using current DNA analysis methods. The interests of justice require that biological evidence of this significance be subjected to the most reliable scientific analysis available, particularly when questions have been raised about the conditions under which it was originally handled. That is, the remaining biological material from Vale's coat, a portion of the bloodstain that had been preserved according to standard evidence retention protocols, was sent to an independent laboratory specializing in forensic DNA analysis in the state capital. The analyst assigned to the case was Juniper, a certified forensic scientist with advanced training in low-template DNA analysis and mixture interpretation using probabilistic genotyping software that hadn't existed when Rook was convicted. Juniper worked on the sample for 7 weeks. The bloodstain had been stored for 28 years, subjected to multiple freeze-thaw cycles due to the temperature fluctuations documented in the audit, and was significantly degraded at the molecular level. But modern short-tandem repeat profiling methods, combined with probabilistic genotyping algorithms, could extract meaningful data from partial and degraded DNA profiles that earlier methods couldn't reliably interpret. The software could analyze complex mixtures, account for degradation artifacts, calculate statistical weights for different contributor hypotheses, and generate likelihood ratios comparing competing explanations for the observed genetic data. Juniper generated a complete STR profile from the bloodstain using 16 genetic loci, more markers than had been analyzed in the original testing. She then compared that profile to Rook's reference sample, which was also retested from preserved material. Exclusion. The profile from the bloodstain did not match Rook's genetic profile. The exclusion was absolute across multiple loci. Rook could not have been the source of the blood on Vale's coat collar. Juniper then ran the profile through the state's convicted offender DNA database and the national CODIS system to determine whether the blood belonged to anyone in the system. A hit came back within hours. The DNA profile matched a man named Flint, who had been convicted of aggravated assault in a neighboring county 3 years after Rook's trial, and was currently serving a sentence at a different correctional facility. Flint had never been a suspect in Vale's murder. His name appeared nowhere in Detective Harbour's investigative file, but his DNA was on her coat. Juniper's written report, filed with the court as an exhibit to North's motion for a new trial, documented in meticulous detail the contamination pathway that had led to Rook's wrongful conviction. Item C47, Vale's coat sample, had been stored directly adjacent to item X89, a blood-stained shirt from Flint's assault case that had been processed by Arcadia Lab 4 months after Rook's evidence was analyzed, but before his trial. Both evidence tubes had been stored in the same freezer compartment with inadequate separation. Both tubes showed seal degradation in photographs from the audit. Trace biological material transfer between adjacent samples under those storage conditions was not only possible but likely according to current understanding of DNA transfer mechanics. The original analyst, Drift, had processed both the Rook case and the Flint case during overlapping time periods. Under modern contamination prevention protocols, Drift's testimony at trial about batch separation and prevention of cross-contamination was unsupportable given the actual storage practices at Arcadia Lab during that period. The profile originally attributed to Rook had almost certainly been the result of DNA transfer from Flint's evidence to Vale's coat sample, while both were stored in Freezer Bay 3, Shelf B. The evidentiary hearing on North's motion for a new trial filled Judge Keystone's courtroom to capacity. Reporters occupied the back rows. Rook's sister sat directly behind the defense table. Vale's brother attended with 2 family members, their faces drawn and tense. This was, in many ways, a second trial, not of guilt or innocence in the traditional sense, but of whether the system that had convicted Rook 28 years earlier had convicted the right person. North called Juniper as her first witness. Juniper, composed and precise in her testimony, explained the STR profiling process in language the court could understand. She walked through her analysis step by step, showing exhibits of the genetic data, the comparison charts, the exclusion at multiple loci, and the database match to Flint. On cross-examination, Slate pressed her hard on the possibility that both Rook and Flint had somehow contributed DNA to the coat, a mixture that the original testing hadn't detected. Juniper's answer was technically detailed but unequivocal. The profile from the bloodstain was single source, not a mixture, and that source was Flint, not Rook, with a statistical certainty exceeding 1 in 1 trillion. North called a forensic evidence storage expert, a professor from a university forensic science program, who testified about DNA transfer mechanisms, degradation timelines, and the contamination risks present in Freezer Bay 3 based on the audit documentation. Slate objected repeatedly, arguing that the expert's opinions were speculative and not based on direct knowledge of the specific samples. Judge Keystone overruled most objections, finding the testimony relevant to understanding how contamination could have occurred. The state called Drift, now 71 years old and long retired from Arcadia Lab, as a rebuttal witness. Drift defended the original analysis with visible emotion, insisting that protocols had been followed to the best of his knowledge and ability at the time. But under North's cross-examination, Drift was forced to admit that the batch processing logs for Rook's case showed timing irregularities, that no photographic documentation of the physical storage arrangement in Freezer Bay 3 existed from that period, that he had no specific memory of handling those particular samples given the passage of time, and that he'd been unaware of many of the storage problems identified by the Oversight Board audit until reading about them in the newspaper. Kane, the jailhouse informant whose testimony had been so damaging at trial, was deceased. He died 7 years earlier from liver disease. But North introduced sworn affidavits from 2 former inmates who'd been housed near Kane during the same period. Both men testified in their affidavits that Kane had openly bragged in the jail about manufacturing testimony in exchange for sentencing leniency in multiple cases, that Kane had actively sought out high-profile defendants to cultivate, and that Kane had access to case information through contacts in the jail, including guards and trustees who moved between cell blocks. One affidavit included a photocopy of a letter Kane had written to a prosecutor in an unrelated case, offering to deliver cooperative witnesses in exchange for charge reductions on his burglary case. Slate fought hard to exclude the affidavits as inadmissible hearsay and inherently unreliable, given the declarant's own criminal histories. Judge Keystone ruled that while the affidavits couldn't be used as substantive evidence of Rook's innocence, they were admissible for the limited purpose of impeaching Kane's credibility and demonstrating that his trial testimony may have been fabricated, an issue directly relevant to whether Rook received a fair trial and whether the verdict was reliable. Most significantly, North introduced evidence that Kane's knowledge of the missing canvas tote bag, the detail Slate had emphasized at trial as proof of Kane's credibility, had been in a police report that was accidentally included in a public records request response published on the county's website 6 months before Rook's trial. A paralegal had discovered this while researching the case history. The secret detail that supposedly only the killer could know had been publicly accessible to anyone, including Kane, who was in the county jail with regular access to newspapers and the law library, where inmates could use monitored internet terminals. After 5 days of testimony, North moved for a directed verdict of acquittal under the state's actual innocence gateway standard for post-conviction relief. The standard, recently clarified by the state Supreme Court, required new evidence that was reliable, material, and would likely create reasonable doubt had it been available at the original trial, such that no reasonable juror would have voted to convict. Your Honor, The DNA evidence was the prosecution's entire case, North argued in her closing statement to the court. The prosecutor told the jury in opening statements that the science was irrefutable. That same evidence has now been irrefutably proven false. The DNA on Vale's coat was not Rook's. It belonged to another man entirely. Without that DNA match, there is no case against Rook. The informant's testimony has been thoroughly impeached as fabricated. The circumstantial evidence of proximity and opportunity, standing alone, doesn't remotely meet the burden of proof beyond reasonable doubt. Rook has been in prison for 28 years for a crime he did not commit. The evidence demands his immediate release. Slate, his face tight with frustration but his voice controlled, countered that even without the DNA, the totality of the circumstantial evidence still supported Rook's guilt. The geographic proximity, the lack of a solid alibi, the informant's detailed knowledge of the crime scene, the presence in the area on the night in question, all of these factors, Slate argued, remained unchanged by the DNA retesting. The defendant is asking this court to second-guess a jury verdict based on a single piece of discredited evidence, Slate said. But convictions can rest on circumstantial evidence. The jury heard all the facts and made their determination. That determination should stand. Judge Keystone took the matter under advisement. The courtroom cleared slowly, with spectators filing out in near silence. Rook was returned to his holding cell to wait. 2 days passed. North called to say the judge was reviewing the entire trial transcript and the new evidence exhibits. Another day. Rook couldn't eat. He stared at the cell ceiling and counted the hours. On the afternoon of the 4th day, Judge Keystone's clerk called North and instructed her to bring Rook to court the following morning for a ruling. North visited Rook that evening in the jail. "Whatever happens tomorrow, we did everything we could," she told him. "The evidence is on your side." "I believe the judge sees that." Rook nodded but didn't respond. Belief felt dangerous. The courtroom the next morning was packed. Every seat in the gallery was filled. News cameras lined the back wall. Judge Keystone took the bench at precisely 9 a.m. The bailiff called the courtroom to order. The ambient noise of shifting bodies and whispered conversations died to complete silence. The court has carefully reviewed all testimony and exhibits presented during the evidentiary hearing, as well as the complete trial record from the original proceedings, Judge Keystone began, reading from a prepared written order. The question before the court is whether the newly discovered evidence is material, reliable, and of such significance that it undermines confidence in the verdict and would likely have resulted in a different outcome at trial. She paused, looked directly at Rook across the courtroom. The court finds that the newly discovered DNA evidence is not only material and reliable, but dispositive. The original conviction rested heavily, overwhelmingly in fact, on the DNA match testified to by analyst Drift. The prosecution's theory of the case, the closing argument, and the verdict itself all turned on that scientific proof. That proof has now been conclusively refuted. The DNA on the victim's coat was not the defendant's. The original analysis was the product of cross-contamination at the state laboratory, a fact that has been established through credible expert testimony and documentary evidence. Rook felt his pulse in his temples. His sister was crying quietly behind him. Judge Keystone continued. Furthermore, the court finds that the informant Kane's testimony, which provided additional support for the verdict, has been thoroughly impeached. The affidavits presented demonstrate that Kane had a pattern of fabricating testimony for personal benefit, and the so-called corroborating detail about the victim's tote bag was publicly available information, not secret knowledge that only the perpetrator could possess. Stripped of the DNA evidence and Kane's discredited testimony, the remaining circumstantial evidence, proximity, opportunity, and alleged presence in the area, is insufficient to support a conviction beyond reasonable doubt. Many innocent people live or work near crime scenes. That fact alone does not constitute proof of guilt. She looked down at her written order, then back at the courtroom. The court therefore concludes that the defendant has met the rigorous standard for post-conviction relief on actual innocence grounds. No reasonable jury, presented with the evidence now available, would have convicted the defendant. The original verdict cannot stand in light of what we now know to be true. Judge Keystone's voice strengthened. The court hereby vacates the defendant's conviction for second-degree murder. The charges against the defendant are dismissed with prejudice, meaning they cannot be refiled. The defendant is ordered released from custody forthwith. Bail is not required because there is no case pending. Mr. Rook, you are a free man. The gallery erupted in noise. Rook's sister sobbed loudly. Reporters bolted for the doors. Vale's brother stood abruptly and walked out, his face a mask of anguish and confusion. North gripped Rook's shoulder, saying something he couldn't hear over the commotion. Rook sat motionless, trying to understand that the words he'd just heard were real. Processing out of custody took nearly 4 hours due to bureaucratic requirements, even for an exoneration. Rook signed release forms, received a debit card loaded with $47 in statutory discharge funds, and was handed a clear plastic bag containing the clothes he'd been wearing when arrested 28 years earlier. The jeans didn't fit anymore. He'd lost weight in prison. The shirt was yellowed with age. North had anticipated this and brought a donated jacket and pants from the public defender's clothing closet. Outside the main gate of Coldbrook Correctional Facility, Rook stood on the curb in the afternoon light, breathing air that somehow tasted different than the air inside. The sky was overcast with low clouds threatening rain. A commercial jet passed overhead, and Rook watched it until it disappeared into the cloud layer. His sister was waiting in her sedan in the visitor parking lot. She got out when she saw him and stood by the car, uncertain whether to approach or wait. Rook walked to her slowly. When he reached her, she hugged him carefully, as if he might break. They stood that way for a long moment before she opened the passenger door. They drove in complete silence for the first 30 minutes. Rook watched the landscape change from rural to suburban to urban as they approached Riverbend. Everything looked different. New buildings where he remembered empty lots, businesses that hadn't existed, roads that had been expanded or rerouted. 28 years of change compressed into a single drive. "I made up the guest room for you," his sister said finally, her voice tight. "You can stay as long as you need to, as long as you want." Rook nodded but didn't speak. Language felt difficult. At her house, a modest bungalow in a residential neighborhood, she showed him to the small bedroom at the back. There was a twin bed with fresh sheets, a dresser, and a lamp. Rook sat on the edge of the bed and tried to remember what it felt like to be in a room with a door he could open himself. His sister said she'd make coffee and left him alone. He looked at his hands. They were the hands of a 51-year-old man, but he felt both ancient and newborn. Free, but not remotely whole. The state's compensation statute for wrongful incarceration allowed for $50,000 per year of unjust imprisonment, with a total cap of $1 million. Rook's 28 years of confinement exceeded the cap, meaning his maximum possible compensation was $1 million, despite the duration of his suffering. North explained that the claims process would require extensive documentation, multiple hearings before a compensation board, and likely 6 to 12 months before any payment would be issued. The burden of proving eligibility fell on Rook, even though the state had already conceded his innocence by vacating the conviction. Rook's criminal record was expunged by court order, but the gaps in his employment history remained. Job applications asked for a complete work history and references from the past decade. Rook had neither. His Social Security earnings record showed zero income since his arrest. Reintegration programs run by non-profit advocacy groups offered resume writing workshops and mock interview coaching. Rook attended one session at North's urging. The workshop leader was 26, energetic and well-meaning. She explained how to reframe gaps in employment history. Rook left after 45 minutes and didn't return. A journalist from the Riverbend Herald contacted him through North, requesting an interview for a feature story about his exoneration. Rook declined. "There's nothing to say that matters," he told North when she relayed the request. "Vale is still dead. I'm still destroyed. Flint is in prison for something else. And nobody knows if he actually killed her or if his DNA got on her coat some other way. Writing an article doesn't change any of that." Flint had been contacted by detectives from the Riverbend Police Department cold case unit after Juniper's DNA match came back. He'd been transported from his facility to Granite County for questioning. According to North, who'd received updates from the DA's office, Flint had denied any involvement in Vale's death. His aggravated assault conviction stemmed from a bar fight in another city that had left a man with permanent injuries. Flint claimed he'd never been to the industrial district where Vale was killed, had never met her, and had no explanation for how his DNA ended up on her coat. The detectives reviewed all available evidence and consulted with Slate's office. Without additional proof linking Flint to the murder scene beyond the DNA on the coat, DNA that might itself have resulted from the laboratory contamination, the DA concluded there was insufficient evidence to charge Flint. The cigarette butt DNA remained unidentified in the database. Vale's murder investigation was officially reopened, but effectively cold again. Vale's family issued a brief statement through their attorney 2 weeks after Rook's release. "We were told for 28 years that justice had been served for Vale. We grieve for her and for the man who lost his life to a fundamentally broken system. We have no answers now about who took Vale from us. We ask the media and the public to respect our privacy as we process this painful chapter." Rook read the statement in the newspaper and felt the weight of it. Vale's family had lived for nearly 3 decades believing her killer was in prison. Now they knew they'd been lied to, that the certainty they'd been given was false, that Vale's real attacker might never be found. His exoneration had stolen their closure without providing them truth. The injustice had metastasized. 3 months after his release, Rook attended a panel discussion at the state law school, where North now worked part-time as a clinical instructor. The topic was forensic error and wrongful convictions. Rook had been invited to sit on the panel alongside 2 other exonerees and several academics. He'd declined initially, but North had convinced him that his presence mattered, that his story could prevent future wrongful convictions. Rook agreed reluctantly. The auditorium was full of law students, professors, and criminal justice professionals. Rook sat at the end of the panel table, uncomfortable in borrowed dress clothes, while the other panelists discussed systemic reforms. Blind lineup administration, mandatory recording of interrogations, open file discovery requirements, robust indigent defense funding, independent forensic science oversight. When the moderator asked Rook to share his perspective, he took the microphone with a hand that trembled slightly. "I don't have policy recommendations," he said quietly. "I'm not a lawyer or a scientist, but I can tell you what it feels like to sit in a cell for 28 years knowing you didn't do what they said you did, and knowing that nobody believes you. I can tell you what it's like to watch your mother die while you're locked up for a crime you didn't commit and not be allowed to attend her funeral. I can tell you that even though I'm technically free now, I'm still in that cell in every way that matters. I'll be in that cell for the rest of my life." He paused, looked at the students. "The system didn't just make a mistake with me. It didn't just get the wrong guy. It deliberately chose certainty over truth. The prosecutor told the jury the DNA was absolute proof. The analyst said contamination was impossible. The informant was rewarded for lying. And when I tried to appeal, every court said the evidence was overwhelming and the conviction was sound. 28 years. That's what certainty cost when certainty was wrong. The auditorium was silent. Rook set down the microphone. During the Q&A session afterward, a student asked how he'd survived with his sanity intact. Rook's answer was honest. I didn't survive. This isn't survival. I'm a ghost in borrowed time. The law school later announced the creation of a wrongful conviction clinic with dedicated funding for forensic experts and investigators. North became its founding director. Rook's case was featured in the clinic's training materials as a textbook example of laboratory contamination, informant perjury, and the dangers of over-reliance on seemingly objective scientific evidence. The clinic's mission statement referenced him by initials only, but everyone involved knew whose story it was. Rook moved into a small one-bedroom apartment in a subsidized housing complex funded by a victims' advocacy nonprofit that had expanded its mission to include exonerees. The walls were beige, the carpet was worn. The furniture had been donated by church groups, a sagging sofa, a scratched dining table, 2 chairs that didn't match. He had no photographs to hang because all the photographs from his previous life had been lost or destroyed during his incarceration. His mother's funeral had happened without him. Her house had been sold to pay for her end-of-life care. The life he'd had before arrest was archaeologically gone. He applied for Social Security disability benefits, claiming severe PTSD, adjustment disorder, and major depression stemming from his wrongful incarceration. The initial application was denied with a form letter stating that his condition didn't meet the medical criteria for disability. North helped him file an appeal with supporting affidavits from a psychologist who'd evaluated him. The appeal process took 13 months. It was ultimately approved, with retroactive benefits dating to his release. The monthly payment was enough to cover rent and food, but not much else. On the first anniversary of his release, Rook walked to the alley where Vale had been found. The old textile warehouse was gone, demolished 5 years earlier, according to a historical marker he found on the sidewalk. In its place stood a modern condominium complex with retail space on the ground floor. A coffee shop, a yoga studio, a boutique selling handmade jewelry. The alley itself had been converted into a pedestrian walkway with decorative brick pavers and solar-powered lighting fixtures. A young couple walked past him holding hands, laughing about something on one of their phones. They didn't notice Rook standing motionless at the entrance to the walkway, staring at the space where a woman had died and a system had lied. He stood there until the sun set and the solar lights activated automatically. Then he walked back to his apartment in the dark, taking side streets to avoid the crowds emerging from restaurants and bars. At home, he sat at the donated dining table and opened the cardboard file box he'd kept throughout his incarceration. He read through the trial transcript one final time, methodically, from Slate's opening statement to Judge Keystone's sentencing remarks. Drift's confident testimony about the DNA match, Kane's detailed lies about the confession, Gable's ineffective closing argument, the verdict. He folded the transcript pages carefully and placed them back in the box along with all the motions, briefs, and court orders that had accumulated over 28 years. The box went into the apartment's small closet, behind the few clothes he owned. He closed the closet door and didn't open it again. Rook began volunteering at the wrongful conviction clinic North directed. He answered phone calls from inmates and their families requesting case review. He filed paperwork and organized case files. He attended hearings for other exonerees at various stages of their post-conviction proceedings. North told him his presence made a difference, that other wrongfully convicted people needed to see that exoneration was possible, that survival after exoneration was possible. Rook wasn't certain either of those things was true, but he kept showing up 3 mornings a week. He met others whose lives had been shattered by wrongful convictions. A man named Ash exonerated after 16 years based on a recanted eyewitness identification that had been coerced by detectives who showed the witness only one photograph and said, "We know this is the guy." A woman named Willow, freed after DNA testing excluded her from a child abuse case built entirely on now discredited shaken baby syndrome medical testimony. They shared strategies for navigating re-entry, where to find apartments that would rent to people with decades-long employment gaps, how to explain the missing years to potential employers without triggering discrimination, how to manage the nightmares and hypervigilance and sudden panic attacks triggered by sirens or locked doors. The compensation funds finally arrived 14 months after his release, deposited electronically into a bank account North had helped him open. $1 million, representing 28 years of stolen life at a state-calculated rate of $50,000 per year, capped artificially because the legislature had decided that was the maximum value they would assign to even the longest wrongful imprisonment. Rook looked at the balance on the bank's website and felt nothing. He donated half immediately to the wrongful conviction clinic, signing the check in North's office without ceremony. The remainder went into a trust fund managed by his sister per an arrangement North had recommended. Rook didn't want to think about money. Money felt like an exchange rate for years, and years couldn't be bought or sold or returned. He enrolled in a continuing education class at the community college, Introduction to Computer Science. He'd always been good with logical systems, and programming seemed like something that might occupy his mind. The instructor was 34, younger than Rook's missing decades. The textbooks referenced technologies and concepts that hadn't existed when Rook went to prison. Smartphones, cloud computing, social media platforms that now dominated how people communicated. He struggled with the assignments, his thinking too rigid and linear for the creative problem-solving the coursework required. But he attended every session and completed every homework problem, even when he wanted to quit. One evening, North called him. Another case, similar facts to his own. DNA contamination at a different regional laboratory. A man named Cedar, who'd been in prison for 19 years. Could Rook testify at Cedar's clemency hearing about the long-term psychological effects of wrongful incarceration? The board needed to understand what they were evaluating when they decided whether to recommend clemency to the governor. Rook said yes. The clemency hearing took place in a conference room at the state capitol building. Rook sat at a witness table, facing a 5-member board of appointed officials. He described the cell at Coldbrook, the parole denial, the moment North had told him about the DNA retesting results, the 4 hours processing out of custody, the disorientation of being released into a world that had moved forward without him. One board member, a former appellate judge, asked if he'd forgiven the system that had wrongfully imprisoned him. Rook considered the question carefully before answering. "I don't think about forgiveness," he said finally. "Forgiveness implies that what happened was personal, like someone wronged me out of malice. But this wasn't personal. It was systemic. It was ordinary. Drift wasn't trying to frame me. He just didn't follow protocols carefully enough, and nobody checked his work. Kane wasn't evil, he was incentivized. Slate wasn't corrupt, he believed the evidence. The system didn't target me, it just processed me. And that's what makes it so terrifying. I think about the other people still inside who don't have a Juniper, who don't have an audit that exposes the problems, who don't have a North willing to fight for years. I think about Vale's family, who were given false certainty and false closure. I think about how many analysts like Drift are still working in labs across the country, following inadequate protocols because nobody's funding better ones. The board granted clemency to Cedar. He was released 2 weeks later. He called Rook from outside the prison gates to thank him. Rook didn't know what to say, so he just listened while Cedar described the sky and the feeling of wind on his face. At the apartment, Rook kept a notebook. In it, He wrote things he was trying to remember, his mother's voice, his sister's laugh before grief weighted it, the person he'd been at 23. He also wrote things he'd learned, that forensic science is performed by fallible humans, that juries trust experts because they have no framework to doubt them, that contamination hides in freezer bays and batch logs, that proving innocence is exponentially harder than proving guilt, that wrongful conviction isn't an aberration but a predictable outcome when efficiency is valued over accuracy. He wrote one final entry. The case is closed. The system said sorry with money that can't buy back time. But the work isn't finished. It will never be finished as long as certainty matters more than truth. One morning, Rook woke before dawn. He made coffee at the donated table and watched through the window as River Bend came alive. Delivery trucks rumbling past, dogs barking, alarms sounding in apartments above and below. He thought about Vale, about the unsolved question of who really killed her. He thought about Flint, whose DNA had condemned Rook through nothing but proximity in a freezer. He thought about the jury, who believed what they were told, because they had no reason to doubt. He thought about the 28 years between lie and truth, and all the people still living in that gap. He opened the notebook and reread what he'd written. Then he closed it, stood, and prepared for another day, outside the cell, but carrying it with him in every breath, every thought, every moment that felt both liberated and imprisoned. Freedom, he'd learned, wasn't a gate opening. It was learning to exist in a world that had continued without you, marked permanently by the system's mistake. The truth had come. The verdict was reversed. But some things, once broken, can never be wholly repaired. If this story resonated with you, explore more cases where forensic reinvestigation revealed the truth years after conviction, and share your thoughts on how we can prevent these tragedies.